Hi. Often I receive query whether I can transfer property to my near and dear relatives, maybe son or daughter or wife. So what is the cost it will incur and how I have to do it? So I thought I will make a video on this topic. My name is Girish Rao. I am advocate and solicitor. I have nearly 30 years of experience. And this video is brought to you by Legal Scholar Academy. Legal Scholar Academy conduct courses on various topics of law. So if you want more detail about it, kindly connect with the Legal Scholar Academy on the number which will be scrolling down here. So now, and if you are already not subscribed to this channel, I request all of you to subscribe to this channel so that whenever we upload a new video, you will get a notification about it. We regularly upload video on various topics of law, which will be of your interest, which I am sure if you are watching this video, that's going to also be of your interest. Now, and other thing which I don't want you to forget is to hit that like button because I know you are going to like this video. Yes. Now let's start our today's topic. Yeah. What is in this today's topic is basically often I receive the query whether I can transfer my property. I am assuming in this case you are a member of a cooperative housing society. So whether you can transfer your flat to your son, daughter or wife and how I can transfer it. So I am going to split it in two, three manner. Number one is that how to transfer it. Then what is it require or what is the stamp duty which you will incur for transferring the property or the flat. And another thing is that the registration invariably will be required whether whichever you do, but only thing which aspect which you have to see is that stamp duty aspect for transfer of the property. So I will screen share so that it will be easier for me to explain it to you and then we'll proceed further. So first question is A is the owner of the flat. Let's assume flat and he's a member of a society and he wants to give it to his son or daughter. So how he can give it? That's the first question. Then second question is A and son are the joint owner of the flat and they are member of the society. A wants to give it to his son and how can he give it? That's the second question. And third question is about the nominee, but I am going to make a different video for that. I am not covering it in this video, but just for sake of your completeness, uh, often the question is asked whether is nomination sufficient. Uh, if a person, rather, if a person makes nomination, is it sufficient? And well, the property will get transferred to the nominee, for which a big answer is no. I will be explaining in detail about it in another next video which I will be publishing it. So now in this video I am answering only two questions. Now first question is A is a member of the society and then he is the owner of a flat and he wants to give it to his son or daughter. How he can give it? See, he can give it by way of gift. That is the only way he can give it. See, when we are talking about a person giving something to another person, and if it is without any consideration, that means without any payment of money, then it is bound to be by way of it's called as a gift, which is covered in Transfer of Property Act. So you will have to make a gift deed for that purpose. When you are making a gift deed, it will have to be also registered. Gift deed will have to be registered to really transfer a property from yourself to your son or daughter, whosoever it is. Then it will attract a stamp duty. Now question is how much will be the stamp duty. So now let's understand what is going to be the stamp duty for such kind of transaction which you will be doing. Right? Transaction rather with the gift which you are giving. So I am talking right now about in the state of Maharashtra. Every state has their own stamp duty law. So you can check up that in your state and accordingly on basis of that you take a decision. And other thing is don't confuse yourself with stamp duty and registration charges. Registration charges is separate and stamp duty is separate. So don't confuse yourself. You will have to pay stamp duty also, registration charges also. In Maharashtra, it is maximum 30,000 rupees. I am not sure about what in different state what are the registration charges and stamp duty. So you have to check your local law. But what I am explaining here is the how you can transfer it. So now when we are talking about gift, because you are not taking any consideration, you are not going to take any payment from him, so it will becomes a gift. So in Maharashtra, under Maharashtra Stamp Act, deals with that. uh, when you are making a gift deed, so what is the stamp duty? Stamp duty for that is, it will be as under, it will be like that of conveyance under article 25 5, and it is under article 34 of the schedule to the Maharashtra Stamp Act. Article 34 states what is going to be the stamp duty on the gift, and it says that it will be like a conveyance under article 25. That means 5% is going to be the stamp duty. And again, in addition to that, depending upon which area you are, there could be some local cess and charges, sometimes 1% and sometimes 2% also. So again, I am telling you here, don't get confused, only stamp duty. Even if stamp duty is reduced, you will may have a local cess and local charges. I think in Thana we have metro cess. So depending upon what kind of, which place you are, there might be some additional charges also. Now I am restricting myself to only stamp duty. Okay. So now when it is a gift, the stamp duty is as conveyance, that is going to be 5%. Now let's see what is the advantage when you are giving it to near and dear one. So for that, the article 34 of the Stamp Act also deals with it. I think earlier somewhere I told 43, just ignore that, is 34. So if it is gifted to the, gift is to the family member, in that case, being, see, if property is gifted to a family member, being husband, wife, brother, sister, or of the donor, means the person who is giving that property, if he is giving it to his husband, wife, brother, sister, or any lineal descendant or ascendant. That means lineal means linear, ascendant means somewhere above, means father, grandfather, or and descendant means lower, son, grandson, or so, grandson, like that, or great grandson. Then amount of duty chargeable shall be at rate of 3% of the market value of the property, which is subject matter of the gift. So conveyance you are getting, you have to pay 5%, but when it is to the family member which is indicated over here, that is indicated over here means that, see, understand, stamp duty is a fiscal fiscal act, and when you are talking about, say, it is strictly interpreted. That means it can't be someone, a wife's sister or someone else. So it has to be wife, brother, sister. So it can't be even nephew, or you can't cross that boundary also. When you are giving it to these people, then the stamp duty will be reduced and it's going to be 5%. Sorry, not 5%, 3% of the market value. Then there is another provision which says, if it is a agricultural land, or if it is a residential property. So let's see what are the discount, or what is how much reduced stamp duty you will have to pay. So when it is a residential property or agricultural property which you are giving by way of a gift, and is again here, if residential and agricultural property is gifted to husband, wife, son, daughter, grandson, granddaughter, wife of deceased son, see, wife of a deceased son. So basically it is they are keeping within the close close this is close family circle, and in that case amount of duty will be rupees 200 rupees. So only for rupees 200 rupees, if it is a residential property and agricultural property, and it is gifted to husband, wife, son, daughter, grandson, granddaughter, wife of deceased son. So basically it's a son. In that case, the duty will be chargeable, will be only rupees 200 rupees. Again, so granddaughter, grandson could be of also a daughter's daughter also. Yeah, that will be covered in this. So in that case, the stamp duty will be 200 rupees. So this is what, when you are giving a gift to your daughter or son or your wife, the stamp duty and what are the document which is required to be executed. Now we will take second topic. Before that, if you have any query, you can just drop a email in the this thing, which is scrolling down here on the email, or you can just ask on the WhatsApp also on the number which is given. Only thing is that please don't keep it too long and keep continually on, and don't WhatsApp in at the wrong time at 11:30, 12 o'clock and all those things in night time to say. Now let's come to the second topic. Now the second question. In this case, what? A, that means a person and son or wife, whatever, whosoever it may be, wife, son, daughter, are joint owner of the flat, and A wants to give his share to his son or daughter, whosoever it may be. How can it be done? As I explained you, when we are talking A person giving it to B person, there has to be a transfer. Transfer could be by way of transfer deed, by way of gift if it is not for any payment. And now one more matter, when we are talking, if they are a joint owner, it can be also by deed of release. That is releasing your right in the property. That is another way it can be done. So coming to that part. So as explained to you, if it is by way of, it can be done by way of gift or by way of release deed if the person are jointly owning the property. Then what was the stamp duty on the gift is already explained to you in earlier earlier in this video. So now what is the stamp duty on the deed of release? Let's understand that. Stamp duty on the deed of release. Article 52 of the deals with the stamp duty. Article 52 of Maharashtra Stamp Act. So please, again I am repeating, this is what I am talking about in for state of Maharashtra. If you are from any other state, you check up in your state what is the stamp duty in your state, and accordingly take the call what should be executed. If it's a release deed of an, see here again what is there. If it is a release deed of an ancestral property or part thereof is executed by or in favor of brother, sister, children, or renounces son or daughter, or son of predeceased son or daughter of a predeceased son, or father or mother or spouse of renounces of the legal heir of the above, the relationship, without any consideration, it will be 200 rupees. So what is here they are telling is, if it is ancestral property, and for ancestral property, if you are executing release deed to XYZ people, in that case it will be 200 rupees. Ancestral property which is in favor of brother, sister, son, daughter, son of deceased, predeceased son, daughter of predeceased son, father or mother or spouse of the renouncee, or legal heir of above relationship without any consideration. So what is required if it's ancestral property? Ancestral property means basically which you have received or which you are entitled by way of as an from the ancestor, from your father or your grandfather, which it has come to your share. That is what ancestral property. I am not going detail in this, but that is a normal generally an ancestral property. That could be issued discussion on that. We'll have a separate video for that. So only if it's ancestral property, then it is 200 rupees. Then in other cases, it will be like that of a conveyance. So if there is a release deed, if you go for your flat, in that case, if it is not ancestral property, then you will end up paying higher stamp duty. So it will be always advisable, even if you are a co-owner, to give it by way of gift deed, right? So this is how you have to transfer, or you can transfer the property to your near relative, or means near relative means I mean to say your family members. If you want to transfer the property, take into consideration this aspect of the stamp duty, how much stamp duty will be attracted, and then you can decide it. In another video which I am making is on the nomination, whether nomination sufficient, what are the law related to nomination, that I am making it in another video. Till then, goodbye. If you have any query, do drop a message or email to us. We'll certainly reply to that. Thank you. Again, once again, reminding you to kindly subscribe to this channel, and also press that thumbs up button and like this video. And if you have a comment, please do put it in the comment box. Thank you. Take care. Bye bye.